Hey everyone, this is your classmate Michael Burkett in IL 707 Law and Governments, and I'd like to present to you this PowerPoint to explain the Students First Act of 2011 for the state of Alabama. Why did the state legislature enact the Students First Act? It was a new 10-year system replacing both the Fair Dismissal Act from 2004, heretofore referred to as FDA, and the Teacher Tenure Act, referred to as the TTA moving forward. According to the Association of School Boards, Students First was a better system, and it would save school boards both time and money, eliminating the arbitration process that was a part of the FDA, the Fair Dismissal Act. The School Board Association also noted that teachers who were fired or suspended continued to receive pay until the arbitration process was complete. And the arbitration process was a lengthy process, and so by eliminating the time needed for arbitration, the school board argued they were able to save thousands of dollars. As far as who is covered by the Students First Act, teachers and education support professionals in Alabama, including those who work not only in K through 12, but also those who work in a 2-year post-secondary institution. Those who work for a 4-year college or university are not covered, but it does afford due process to all school employees. It also applies to classified employees moving from probationary status to non-probationary status. For non-tenured personnel, the protection offered is if terminated by the end of the school year, the non-tenured teacher must receive notice of termination 30 days prior to the date on which the board is going to vote on the recommendation of the superintendent to terminate. The non-tenured teacher is also allowed to submit a written statement to the superintendent and board of education explaining why the termination should not take place. For tenured personnel, the protections are a little more extensive. First, tenured teachers have 15 days to request a hearing, and if that hearing is requested, it must be held within 30 to 60 days of the request. Tenured teachers also have the right to appeal to a retired Alabama judge for a review of an adverse decision by filing with the state superintendent. Once the judge has that in his hands, he has 5 days to render a decision. He or she has 5 days. The judge cannot choose a new course of action. He has to either uphold the board's decision to terminate or reinstate the teacher. Either party has a right to appeal the judge's decision to the Court of Civil Appeals. For non-tenured teachers concerning non-renewals and termination, teachers can be non-renewed or terminated by recommendation of the superintendent and a majority vote of the Board of Education. Non-tenureds must be notified 30 more days, as previously stated, before the scheduled vote. If the non-renewal for the non-tenured teacher is not effective by June 15th, the teacher has an automatic rehire contract for the next school year. If the teacher is in the tenure year, notice is due by the last day of school. For the non-tenured teacher, there is no right to an appeal, and of course, we all know this just from experience, there is no explanation required for the termination. For tenured teachers, they can be terminated for the following reasons: justifiable decrease in the number of positions, incompetency, failure to perform duties in a satisfactory manner, neglect of duty, insubordination, immorality, or any other good and just cause. Teachers cannot be terminated for political or personal reasons. For the tenured teacher, a notice of termination, including the reasons, which is different for non-tenured, for the action taken must be sent to both the teacher and the Board of Education. The teacher then has 15 days to request a hearing, and the hearing, of course, must be held within 30 to 60 days of notice. Continuing with the tenured teachers, the teacher has the right to appeal to the retired judge, and then, of course, either the Board of Education or the teacher have the right to appeal the retired judge's decision to the Court of Civil Appeals. The process for the teacher appealing to the retired judge is as follows. A request is sent to the state superintendent, and the state superintendent sends a request to the executive director of the Alabama Bar Association. And then the Alabama Bar Association appoints a list of 5 rotating retired judges, which are all trained in dispute resolution. And then, of course, the Board of Education and the teacher both have the ability to agree immediately, or they each have the right to strike up to 2 judges, which would be replaced. While the appeal is ongoing, the teacher receives pay and benefits for up to 75 days from the Board of Education's decision to terminate. If the review is complete before 75 days pass, then of course pay is cut off upon the judge's decision. If the 75 days benefit does not include those terminated for immorality, moral turpitude, which, turpitude is a fancy word. I thought I would explain it. Violations of acceptable community standards, neglect of duty, or incarceration. So those teachers who would be terminated for those 4 reasons would not be entitled to the 75 days of pay and benefits. On reassignments and transfers, this particular slide is for reassignments. Employees may be reassigned or transferred to any position for which they're qualified, whether it be skill or training or experience. In a teacher's case, a praxis score. Only the superintendent has the authority to authorize reassignments and transfers. And board approval is not necessary if the reassignment is within the first 20 days after the school year begins. The teacher has the appropriate certification, and the reassignment is made by the superintendent. And of course, that process is only allowed once per school year. That's one thing that I learned while doing this presentation. I did not realize that the superintendent did not need board approval as long as those qualifications were met, specifically the 20th calendar day, not the 20th school day, but the 20th calendar day. After school begins, the superintendent can move a teacher if the superintendent, desires. As far as transfers go, tenured teachers may be transferred to another school within the district as long as the teacher holds appropriate certification, receives no reduction in compensation, and the transfer is approved by the Board of Education. Again, this process is only allowed once per school year and must also take place within 20 days of the start of the school year. Once the superintendent notifies the Board of Education of a proposed personnel action, there is not to be any discussion between superintendent and the Board of Education or among the Board of Education members themselves. As far as terminating, for a certificate action, if a teacher's certificate is revoked, that teacher is immediately terminated upon the revocation of the certificate. If a teacher's certificate is revoked due to a conviction in a court of law, and then later the conviction is overturned, then the state superintendent is responsible for reinstating the certificate, and then the school district that the teacher last worked would be responsible for either putting that teacher back into the job that the teacher held or put that teacher on paid administrative leave with back pay and benefits from the day of termination. I think the key point here is the back pay that you would receive, or a teacher would receive back pay for the days after termination and before reinstatement. For an employee to be suspended, the employee can be suspended for cause with or without pay on recommendation of the superintendent and approval of the Board of Education. If the suspension is less than 20 days or less, the decision cannot be appealed. I've seen that happen many times in the arena of athletics, where a coach has made a mistake on a game day perhaps, or at a practice session, and receive a 15-day suspension. And of course, the reason that Board of Educations or superintendents or principals decide to go that route is they do not have to have any kind of approval there. If it's 21 or more days, the employee has the right to the same appeals process as if they had been terminated. For partial cancellations of a contract or a reduction in force, the tenured teacher and, of course, the non-probationary classified employees can be involuntarily, notice that word, involuntarily transferred to a position with less pay, but due process is the same as a proposed termination. So all of the appeals would be in place. Reassignments that are made as a part of a consequence of or in conjunction with reduction in force in order to comply with state and federal law are not subject to challenge or subject to review. And of course, as stated earlier, teachers can be transferred or non-renewed for any kind of justifiable cause. Resignations from teachers. Teachers must give 30-day notice if the teacher is trying to resign before the next school year. It must happen within 30 days or before 30 days, so at least 31 or more days before the school year starts. There is only 5-day notice required if an employee resigns at any other time in the school year. During the school year, what have you, but if it's right before the school year, it's got to be at least 30 days before. If any teacher violates the 30-day notice or the 5-day notice, that teacher is guilty of unprofessional conduct, and the state superintendent could revoke or suspend the teacher's certificate. This is a list of references that was used for this presentation, an article from AO.com at the bottom, and of course the AEA website, as well as Elmore County Schools website for the full length and presentation of the Students First Act. Thank you very much for watching.